regarding your philosophy, your approach to judging, as well as many specific legal issues. And yet one question that I suspect most of the American people are most curious about is the simplest but perhaps the most important one. Why do you want to be a Supreme Court justice? Anyone in your position would be flattered and highly honored to be nominated to the Supreme Court because it is the pinnacle of the legal profession. But whatever this appointment means to you, what is most important to us is what it will mean for the American people. So please tell us, why do you want to serve on the Supreme Court? What issues motivate you the most? And what excites you about the job?
Senator Kohl, it's an opportunity to serve this country in a way that, fits with whatever talents I might have. I believe deeply in the rule of law. The Supreme Court is the guardian of the rule of law. And to be on the Supreme Court and to have that significant and indeed awesome responsibility to safeguard the rule of law for our country is an honor that comes to very few people and is just an opportunity to serve. And that's
Well, I appreciate that very much, but as we said, it's a tremendous honor, clearly, to serve and to safeguard the rule of law, and I'm sure you feel you're capable of doing that. But what are the issues that bring you here today? What are the things you feel most passionate about? How are you going to make a difference as a Supreme Court justice from any of the others who might be sitting here instead of you today?
Well, Senator Kohl, I do think that what motivates me primarily is the opportunity to safeguard the rule of law, whatever the issues that might come before the court. And I think that that's the critical thing. If you don't have a rule of law, if you don't have an independent judiciary that enforces rights, that enforces the law, then no rights are going to be safe or protected. And I think that has to be first and foremost in every judge's mind, not in the way a legislator, might care about some particular issue. I care about the environment, or I care about the economy, or something like that. A judge can't think that way. A judge is taking each case that comes before her and is thinking about how to do justice in that case, and is thinking about how to protect the rule of law in that case, how to enforce the law, whether it's the Constitution or a statute.
I'm sure that those things are true, but Thurgood Marshall cared passionately about civil rights. Justice Ginsburg had a passion for women's rights. Your father had a passion for tenants' rights. I'm sure you're a woman of passion. Where are your passions?
Senator Kohl, I think I will take this one case at a time if I'm a judge, and I think I will try to evaluate every case fairly and impartially, try to do justice in that case. I think it would, not be right for a judge to come in and saying, "Oh, I have a passion for this and that, and so I'm going to, rule in a certain way with regard to that passion." I'm much more a person who I look at an issue before me, a case that might come before me, try to figure out what's right with respect to that issue, with respect to that case. And if you're a judge, of course, that means trying to figure out what's right on the law.
Many Americans following the Supreme Court and our hearings may feel like the Supreme Court is remote and has no impact on their day-to-day lives. So tell us how you are going to help the American people should you be confirmed. How are you going to make a difference in their lives?
Senator Kohl, I think a judge's job is just to decide each case, and it's hard to say exactly how a judge would make a difference in their lives because you just don't know which cases are going to come before you. It's not like a legislature where you get to kind of craft an agenda and say this year we're going to do the following three things. We're going to work on energy legislation, or we're going to work on civil rights legislation. You know, for a judge, it's case by case by case. That's, I think, the right way for a judge to do a job, is one case at a time, thinking about the case fairly and objectively and impartially. And in the course of doing that, of course, people's lives change because law has an effect on people. And you hope very much that law improves people's lives and has a beneficial effect on our society. That's the entire purpose of law. But this isn't a job, I think, where somebody should come in with a particular substantive agenda and try to shape what they do to meet that agenda. It's a job where the principal responsibility is deciding each case, listening to the parties in that case fairly and objectively, and trying to make a good decision on the law.
Well, that's true, but it is also true, as you know, that the Supreme Court decides which cases to take up. There are thousands of cases that come before you for you collectively as justices to decide on which ones you will hear. So you're not just processing cases as they are placed before you. You and the other justices decide which cases you are going to judge. So let me ask you this question. Which ones will motivate you?
Senator Kohl, you're exactly right that the Supreme Court does decide which cases to hear. It's a highly discretionary docket. There are about 8,000 certiorari petitions every year, and only about 80 of them are now taken by the Supreme Court, so maybe 1 in 100. But there are some pretty settled standards for deciding which cases to take. The first thing always is if there's a circuit split, because what the Supreme Court does, one of the principal roles of the Supreme Court is to apply uniformity across our country, so that if one court says X and another court says Y and another says Z with respect to the same issue, the Supreme Court is the one that says we have to take this case so we can just set a clear rule, state what the law is, so that everybody then can follow it across the country. So that's one reason why the court typically grants cert on a case. Another set of cases where the court very typically, often, almost always grants certiorari is when a legislature, when another court has invalidated an act of Congress, when a court has said that an act of Congress is unconstitutional. And there, the court almost always says, well, acts of Congress, that's a serious thing to invalidate an act of Congress. You know, for the most part, we want to defer to the legislative branch, to the decisions of our elected branches. So that's such a serious thing that the court is going to take that case. And then I suppose that there's a third category of cases, which is just extremely important legal issues. You know, cases where there's not a conflict among the courts of appeals and there's no invalidation of an act of Congress, but the case presents some just strikingly significant legal issue that it's appropriate for the Supreme Court to consider and to issue a decision on. And I think, you know, in each year, there's some number of those cases.
General Kagan, as many of us said yesterday, we appreciate the perspective that you would bring to the court as someone who has not been a judge. As Senator Feinstein said, that's a refreshing quality. And we appreciate the many thousands of documents that you've made available to us from your work throughout your career. Yet they shed little light on your judicial philosophy or how you would analyze and evaluate problems as a judge. That is why these hearings are so important, so that the American people can get a sense of what your judicial philosophy is. At his confirmation hearings, Justice Alito said, quote, "If you want to know what sort of a justice I will be, look at what sort of a judge that I have been." And other nominees have said similarly. Since we do not have a judicial record for you, how should we evaluate you so that we do have an idea as to what kind of a justice you will be? What decisions or actions can you point to in your past and your career that demonstrate to us what kind of a justice you will be?
Senator Kohl, I think you can look to my whole life for indications of what kind of a judge or justice I would be. I think you can certainly look to my tenure as Solicitor General and the way I've tried to approach and handle that responsibility. I think you can look to my tenure at Harvard Law School and think about the various things I did there and the approach that I took. I think you can look to my scholarship, to my speeches, to my talks of various kinds. So I think it may not be quite so easy as with a person where you can just say, well, read this body of decisions. But I think I've had very much a life in the law, a very public life in the law. Senator Schumer referred yesterday to all my scholarship, to all my talks. And I think, you can look to all those things. I hope what they will show, and this is for the committee to determine, but I hope what they will show is a person who listens to all sides, who is fair, who is temperate, who has made good and balanced decisions, whether it's as Solicitor General or whether it's as Dean of Harvard Law School or in any other capacity.
Well, I think this is a good time to refer to your 1995 Law Review article in which you criticize the Supreme Court.
It's been half an hour since I heard about that article.
Here we are. You said back then, when the Senate ceases to engage nominees in meaningful discussions of legal issues, the confirmation process takes on an air of vacuity and farce, and the Senate becomes incapable of either properly evaluating nominees or appropriately educating the public. However, more recently, in the meeting that we had, you indicated that you had reconsidered these views. And I think we're getting some indication of that here at the moment. How do you feel about that reconsideration versus what you said back in 1995?
Well, Senator Kohl, I do think that much of what I wrote in 1995 was right, but that I, in some measure, got a bit of the balance off. So what I wrote in 1995 was that the Senate had an important role to play, that the Senate should take that role very seriously, that the Senate should endeavor to think about what a nominee what kind of justice a nominee would make, and that was all appropriate. And I also said that I thought it was appropriate for nominees to be as forthcoming as they possibly could be. And I continue to believe that, and I am endeavoring and will endeavor to do so. I did think, as I suggested earlier, that I got the balance a little bit off. I said then, even then in that 1995 article, that it was inappropriate for a nominee to ever give any indication of how she would rule in a case that would come before the court. And I think, too, it would be inappropriate to do so in a somewhat veiled manner by essentially grading past cases. But I do think it's very appropriate for you to question me about my judicial philosophy on the kinds of sources I would look to at interpreting the Constitution or interpreting a statute, about my general approach to judicial decision-making, about the degree to which I would defer or not defer to acts of Congress and the states. I mean, all of those things, I think, ought to be a subject of debate.
Well, back in that 1995 article, you wrote that one of the most important inquiries for any nominee, as you are here today, is to, quote, inquire as to the direction in which he or she would move the institution. In what direction would you move the court?
Well, Senator Kohl, I do think that is the kind of thing that all I can say, Senator Kohl, is that I will try to decide each case that comes before me as fairly and objectively as I can. I can't tell you I'll move the court in a particular way on a particular issue because I just don't know what cases.
Well, you said in 1995 it is a fair question to ask a nominee in what direction, this is your quote, would you move the court?
Well, it might be a fair question.
I'm not going to get necessarily. All right, let's move on. Comparison to other General Kagan. The basic purpose of this hearing is to learn what kind of a person you are and what kind of a justice you will be when you're confirmed. One way we gain insight into your judicial philosophy is to learn which justices you most identify with. Yesterday you spoke highly of Justice Stevens and said his qualities are those of a model judge. In addition to Justice Stevens, can you tell us the names of a few current justices or justices of the recent past with whom you most identify in terms of your judicial philosophy and theirs?
Well, I do very much admire Justice Stevens, and I wanted to say so as he left the court because I think he has done this country long and honorable service, that he has been a simply marvelous justice in his commitment to the rule of law, in his commitment to principle. That's not to say that Justice Kagan, if I'm so lucky as to ever be called that, Justice Kagan would be Justice Stevens. It's just to say that I have great admiration for the contribution that Justice Stevens has made over many period of years, obviously, but Justice Stevens' contribution to the court is not calculable in years. It's this extraordinary commitment to the rule of law that was there in his first year and is there in his last. I think it would be just a bad idea for me to talk about current justices, and I've expressed, admiration for many of them.
My, oh my, oh my. All right, let's move on. General Kagan, to help us understand what kind of a justice you would be if you're confirmed, I'd like to briefly describe the philosophies of two justices, ask you which comes closest to your view. Justice Scalia considers himself to be an originalist who interprets the Constitution by looking solely at the text. He rejects the notion of a living Constitution and only gives the text of the Constitution, quote, the meaning that it bore when it was adopted by the people in 1787. In contrast, Justice Souter has criticized this purely textual approach as having, quote, only a tenuous connection to reality. He believes that the plain text of the Constitution as written in 1787 does not resolve the conflict in many of today's tough cases. Rather, Justice Souter believes judges must look at the words and seek, quote, to understand their meaning for living people. Which view of the constitutional interpretation comes closer to your view, and why?
Senator Kohl, I don't really think that this is an either-or choice. I think that there are some circumstances in which looking to the original intent is the determinative thing in a case, and other circumstances in which it is likely not to be. And I think in general, judges should look to a variety of sources when they interpret the Constitution, and which take precedence in a particular case is really a kind of case-by-case thing. The judges always should look to the text. There's no question that if the text simply commands a result, senators, you can only be a senator if you're 30 years old, then the inquiry has to stop. But there are many, many provisions of the Constitution, of course, in which that's not the case. When that's not the case, when the text is subject to one or more interpretations, then often you look to the original intent and you consider that original intent carefully. An example of that is in the Heller case, the gun case, where actually all 9 justices in that ruling looked to the original intent. They had different views of what the original intent was, but all 9 of them thought it was important and appropriate to actually think about what the framers had intended when they wrote that language, which of those 2 meanings, the individual right or the collective right, they had in mind. But in other cases, the original intent is unlikely to solve the question, and that might be because the original intent is unknowable, or it might be because we live in a world that's very different from the world in which the framers lived. In many circumstances, precedent is the most important thing. One good example of this is in an interpretation of the First Amendment, where the the court very rarely actually says, what did the framers think about this? The framers actually had a much more constricted view of free speech principles than anybody does in the current time. And when you read free speech decisions of the court, they're packed with reference to prior cases rather than reference to some original history. So I think it's a little bit case by case by case, provision by provision by provision. And I would look at this very practically and very pragmatically, that sometimes some approach, one approach is the relevant one and will give you the best answer on the law, and sometimes another.
I'd like to talk about antitrust a little bit, General Kagan. As you know, it's now been 120 years since the passage of the Sherman Act, our nation's landmark antitrust law. For more than a century, this measure has protected the principles that we hold most dear: competition, consumer choice, and giving all businesses a fair opportunity to succeed or fail in the free market. So those of us who are strong believers in our free market, capitalistic economic system should also support antitrust law, I believe. In the words of the Supreme Court in 1972, antitrust law is a, quote, comprehensive charter of economic liberty. Recently, however, we've seen many industries become increasingly concentrated and consumers having fewer choices. In the last few years, we've seen a series of antitrust cases at the Supreme Court in which the Supreme Court majority has sided with the defendant and, as a result, made it more difficult for consumers and competitors to bring their antitrust cases. Many are concerned that the cumulative effect of these cases has harmed consumers because they are the ones who will suffer by paying the high prices that result from unchallenged anti-competitive practices. These cases include the Legion, Twombly, and Trinco cases, among others. Do you share this concern? Should we be worried that as a result of these cases we've reached a tipping point where the antitrust laws may not be protecting consumers as much as they were intended to do?
Senator Kohl, I know that several of those cases you mentioned are ones in which there is considerable debate. The Legion case is a good example. The Legion case is one in which the court overturned a very long-term precedent, many, many decades precedent, maybe 100 years, the Dr. Miles precedent. And the courts did so really on the basis of new economic theory, new economic understandings, but there's some question, to be sure, as to how new economic understandings ought to be incorporated into antitrust law. There the question was how one should look at vertical agreements rather than horizontal agreements, agreements between a manufacturer and a distributor, and the question of whether those agreements are per se uncompetitive or whether they should be subject to more of a rule of reason analysis. And I believe the court had held that they were per se uncompetitive, non-competitive, or per se violative of the antitrust laws, and changed that to a rule of reason analysis. I think on the one hand, it's clear that antitrust law needs to take account of economic theory and economic understandings, but needs to do so in a careful way, and to make sure that it does so in a way that is consistent with the purposes of the antitrust laws, which is to ensure competition, which is, as you say, to be a real charter of economic liberty.
Well, let's talk about the Legion case. It was a 5-4 decision in which the Supreme Court in 2007 overturned what you correctly referred to as a 96-year-old precedent and held that a manufacturer setting retail prices no longer automatically violated antitrust law. This means, as a practical matter, a manufacturer is now free to set minimum retail prices for his products and prohibit discounting. What do you think of this decision? Do you think it was appropriate for the Supreme Court, by judicial fiat, to overturn a nearly century-old decision on the meaning of the Sherman Act that businesses and consumers had come to rely on and which had never been altered by Congress?
Senator Kohl, I think that decision does present the question that we just talked about, which is, how sort of new economic theory ought to be incorporated into antitrust law, and especially to the extent that the court has already ruled on a case, to the extent that the court already has settled precedent in the area, it does raise the question of what it takes to reverse a precedent, a question on which there is a large body of law. I'm not going to grade the Legion decision, but I do recognize very much the concern that some have said about it, which is this question of when you have precedent in the area, when the antitrust laws have been interpreted in one way over time, and new economic understandings, new economic theory might suggest a different approach, how one balances those two things. And I think that that's a very important question for the court going forward.
General Kagan, how do you feel about permitting cameras in the Supreme Court for oral arguments?
Well, Senator Kohl, this is actually something that I spoke about when I was as Solicitor General before I was ever nominated to this court. So I have expressed a view on this question, and I recognize that some members of the court have a different view, and certainly when and if I get to the court, I will talk with them about that question. But I have said that I think it would be a terrific thing to have cameras in the courtroom, and the reason I think is as when you see what happens there, it's an inspiring sight. I guess I talked about this a little bit in my opening statement yesterday. I basically attend every Supreme Court argument. Once a month I argue before the court. When I'm not arguing, I'm sitting in the front row watching some member of my office or somebody else argue. And it's an incredible sight because all 9 justices, they're so prepared, they're so smart, they're so thorough, they're so engaged. The questioning is rapid fire. You're really seeing an institution of government at work, I think, in a really admirable way. And so I think, and of course the issues are important ones. I mean, not some of them will put you to sleep, but a lot of them the American people should be really concerned about and should be interested in. And so I think it would be a great thing for the institution, and more important, I think it would be a great thing for the American people. Having said that, I mean, I have to say I understand that some of the current justices have different views, have concerns about it. Maybe that they think it would actually change the way the Supreme Court arguments do work, and I would very much want to talk with them about those views. And on almost every issue, I'm open to being persuaded that I'm wrong. But on this one, I have expressed a real view, and it's the one I hold, is that it would be a great thing for the court, and it would be a great thing for the American people.
All right, General Kagan. We all understand that you may be reluctant to comment on cases that will or are likely to come before you. I'd like to ask you a question about a case that the Supreme Court will certainly never see again, the 2000 presidential election contest between President Bush and Vice President Gore. Many commentators see the Bush v. Gore decision as an example of judicial improperly injecting itself into a political dispute. What is your view of that, of the Bush v. Gore decision, and was the Supreme Court right to have gotten involved in the first place, General Kagan?
Senator Kohl, I think I might disagree that it's the kind of decision that will never come before the court again. Of course, you're right that it will never come before the court again. But the question of when the court should get involved in election contests, in disputed elections, is I think one of some magnitude that might well come before the court again. And if it did, I would try to consider it in an appropriate way, and reading the briefs and listening to the arguments and talking with my colleagues. I think it is an important question and a difficult question about how an election contest that at least arguably the political branches can't find a way to resolve themselves, what should happen and whether and when the court should get involved. It's hard to think of a more important question in a democratic system and maybe a tougher one.
Do you believe when these hearings are over this week, the American people should have a pretty good idea of what your judicial philosophy is?
I hope that they will, Senator Kohl, and as we go around the room and people talk to me about the way in which I would decide cases, the approach I would use, just the way you asked me about, would I just look to the original intent or would I look to a broad variety of sources and when and where? I hope that the American people will get a sense of how I would approach cases.
Thank you.
So if people want to understand what's going on, I've mentioned to some of the senators up here, I'm going to yield to Senator Hatch for his round and Senator Feinstein for her round. We'll then take a 10-minute break. We're trying to, if this works right, to break for lunch around 1. We have a vote, and I'm double checking to make sure whether it is set for 2:15. If that's the case, we would vote at, several of us would vote at the desk and come back immediately so that we could start about 2:20 after lunch. But after these two senators ask their questions, we'll break for 10 minutes. Senator Hatch.
Well, thank you, Mr. Chairman. You're doing well. Well, relax as much as you can. I'm going to ask you